I will now call the case of State of Kansas versus Niha Banks, 128424. You may approach counsel when you're ready.
May it please the court, Peter Meharry for the Niha Banks. If I could reserve 3 minutes of my time for rebuttal.
Thank you. Thank you.
Thank you. In this case, my client was convicted of several serious offenses, including felony murder and attempted first-degree murder. The case really centered on my client's claim of self-defense. That was the key issue at trial. It's what her whole defense was about, that she acted because she was in fear for her life and reacted with shooting at the individuals that were endangering her. Along the way, during the trial, we believe the district court made several errors, which we've outlined in our brief. And I'll start with issue one, but I do want to note, I think all of the errors do impact that claim of self-defense, particularly with issue one, and that deals with the hearsay statements that the district court allowed into trial. And those came from statements from one of the alleged victims, Monique Cavett. She did not testify at trial, however. She testified at the preliminary hearing, but by the time we got to trial, the state could not find it. They got her statements in through a third witness who was there as well. And those statements, we believe, painted my client as the one who initiated or provoked the altercation, which ultimately led to the shooting. And that undercuts her claim of self-defense. The district court did give an initial aggressor instruction, which is this court has held and which we know severely limits when a person can use self-defense. So those statements were particularly damaging in this case, and they should not have come into trial. The district court justified it based upon 6460D, specifically all the subsections in that statute, 1, 2, and 3. And we don't believe any of those apply, starting with the first one, which is the present sense impression exception. This court has said, going back to Roe back in the 90s, that that has a rigorous timing element. And that comes from the statute, which states that while the declarant was perceiving the event or condition and which the statement narrates. So it requires somebody to state what is going on as opposed to what has happened. And that's where we think the district court erred here. The statements from Cavett were about what had happened. She said that my client came up to her car, waving a gun, yelling at her, starting the provocation, starting the fight. But that was a recollection. That was recalling what happened. She isn't saying she is up here at my car yelling at me. She is saying she came up to my car and yelled at me. That timing requirement is that tight, because otherwise you lose the reason why we have this exception. And that is the idea that if you're saying, hey, this is what I'm seeing while you're seeing it, it has that indicia of reliability, that you're basically just saying what you're seeing without time for recollection, without time for thought, and without time to change things. So we don't believe it's a present sense impression, or it falls under the present sense impression exception. Likewise, we don't believe it falls under the excited utterance exception. There is no showing that she was freaking out. There's no showing that she was in a panic. She was just saying what had happened. There's no showing that this was sufficiently startling to send her into a panic or send her off the deep end such that she's just blurting things out, which is kind of what that exception applies to. So we don't believe that exception applies either.
Could a reasonable person infer that based on the context that somebody walks up to them, if true, walks up to them with a firearm, that you could imply or infer based on the overall context that would induce an emotional response?
I don't think you can just automatically infer that. I think you need something else in the record to show the person was in a state of panic or hysterical or something like that. And I cited to the Brown case that this court had. and that there was evidence that the person making the statement was distraught, was hysterical, had just witnessed a murder. So I think you need more than just, you know, hey, maybe that did, maybe that didn't. You need something in the record to show that she was actually in a state of panic, and you just don't have that here.
Can you situate the actual statement at issue here in the timeline
The timeline as
of the
in,
events?
of the events.
In other words, the statement that we're talking about is, I think, Cavitt's statement to the witness that testified to the hearsay. Is that correct?
Correct. Yeah, that
When did that statement from Cavitt to the witness occur in the timeline?
the statement from Cavitt to the witness who ultimately testified happened after my client supposedly went up to Cavitt's car and after my client had gone back to her car.
So
And
it happened before the shootings.
it happened before the shootings. That is correct.
But, and to Justice Stiegel's point, it was my understanding that she didn't have a gun right then.
There is conflicting testimony on that, Your Honor. My client's testimony was she had her gun at all times.
Right, but the question is, if, you know, if we're looking at Cavitt and the excited utterance, did Cavitt believe she had a gun?
We don't, I mean,
Because
the
your
statement-
client's testimony was that the gun was, it wasn't showing.
Correct.
Right, so there's no evidence that a gun was seen at the time this alleged excited utterance happened. Or is there?
Well, I mean, the statement that came in was that she was waving a gun.
Yeah, so the statement itself is evidence of that.
Oh,
I would,
admit it.
yeah, if it's admitted, sure. So, I mean, that, the problem, I think, part of the problem is here, this comes in as hearsay. We can't question Cavitt about this. And she, maybe Matt will or will not, but she's a terrible witness. I think we can all agree on that. From her preliminary hearing testimony, she was a terrible witness for the state. She was a terrible witness for everybody. And she was a no-show by the time trial came around. So we have no opportunity to challenge her statements that my client actually did come up to her car waving a gun, because she's not there. And that's why it's important that it specifically fall within those hearsay exceptions, which we don't believe it does. And this allows the state to get in these damaging statements from a bad witness without having to put that bad witness on the stand. So I would say, as far as whether or not she was actually waving a gun, that was highly contested, whether or not my client was. That was the statement of Cavitt, but she wasn't there to testify at trial.
Can I ask you a legal question about subsection 2, the excited utterance exception? The statute talks about the statement being made while the declarant is under the stress of a nervous excitement caused by the perception. There's somewhat of a circular logic, it seems to me, embedded in that. In other words, can the statement itself provide the grounds for the nervous excitement? In other words, just commonsensically, if it were true that someone came up to you waving a gun, it seems very reasonable that that would induce stress of nervous excitement. Do you see what I'm asking?
Yeah, I see what you're asking. And I think you need something else. I think you need some evidence that she truly was
And
in
do
a
we have
panic.
case law that says that? Because my recollection of the case law is we just look at the statement itself and ask, could these facts induce a state of nervous excitement? That's the sort of circularity that.
Yeah, and I'll divide it into two things, I guess. As far as can the statement itself, I think you need more. And I think when you look at case law, this court usually points to other things beyond the statement. Whether or not there's evidence that person is seemingly distraught, crying, whatever it may be. So I think you need more than just saying, hey, this statement provides the basis for an excited utterance. It does seem a little bit circular that you get around hearsay rules with just the hearsay statement. And here, like I said, there's nothing else to show that she was freaking out over this. And frankly, the following events, she then went after my client and beat up my client. So I don't know that she certainly didn't seem terrified in any of those videos. She seemed like she wanted a piece of my client. She went after her. So I don't think there's anything to show that she was sufficiently startled to warrant it coming in as an excited.
Can the fight itself be evidence of, quote, stress of a nervous excitement?
I don't think her conduct in this fight would show that. I think her conduct shows that she was the aggressor in all of this. It wasn't that she was afraid or distraught or hysterical. She was going after my client. So I don't think that provides it either.
And is the ultimate prejudice that you're arguing based on the admission of this evidence that but for the admission, there really wouldn't have been a basis for an initial aggressor instruction for self-defense?
Yeah, this was the only evidence that painted my client as the initial aggressor. The district court, as I said, did give that instruction, which really undermines any claim of self-defense at trial. So I
Well,
think
what
that
about the fight was over and then she went to her car and came back?
she came back for her stuff. She didn't have her cell phone. She came back for her cell phone, and that's when a secondary fight came. And then that's when the car started coming towards her and she fired.
Okay.
So I think when you look at the sequence of events, there was nothing else that showed my client was the one that was provoking this incident.
Before you're out of time, another question on this, but it really bleeds into your instructional error claims as well. Is self-defense, or can you explain how self-defense would have been a legal defense to any of the charged crimes other than the attempted first-degree murder?
It would have been, under this court's case laws, my belief is it would have been an defense to the underlying felony for the felony murder.
How would that be the case?
It was criminal discharge of a firearm, if I'm not mistaken. And
Is there a case that says self-defense is?
this court has talked about forcible felonies. Maybe I don't know the definition of forcible felony, but that seems to be one to me. And she can claim I fired in self-defense. Self-defense is a claim, would be a defense to criminal discharge. If you're saying, if the charge is criminal discharge into a vehicle, well, I fired in the vehicle because you were driving towards me, you can claim self-defense. So if you can claim self-defense to that, that covers felony murder. So I believe self-defense would be a defense to all of the charges that were involved here. With that, as I've argued, we believe that the errors here really did undermine my client's claim of self-defense. Those errors denied her a fair trial, and we would ask this court to reverse.
Any questions, colleagues? Thank you.
Thank you.
Mr. Meharry. Mr. Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I will also focus on issue 1 and submit the remaining issues on the brief unless there are questions.
Just really quickly, could you start by addressing that very last point about which counts we're actually talking about with respect to self-defense?
I looked through my brief. I don't see that the self-defense instruction was necessarily limited in the way that the court gave it. I don't think it was something where the court specifically said you can consider self-defense only
Sure,
with
but
respect.
as a matter of law,
Right.
is self-defense available for the underlying felony of criminal discharge?
I think, to the Your Honor's point, I think that this court's recent case law has certainly called that into question, whether it would be or not. And I think that based on that recent case law, my recollection of it is that it would not be available to the felony murder charge or to the underlying felonies. I didn't specifically prepare for that because, like I said, I think as it was given and because it wasn't raised as an issue in this case, so I'm not as well versed as I'd like to be on that exact case law, but obviously to the extent that it as a matter of law would not have been appropriate, then that would certainly affect the analysis of this court as to whether any error factually had any impact. Turning to issue 1, as this court's well aware, it's an abuse of discretion standard in reviewing a court's ruling on a hearsay objection. Also, as this court's aware, the district court found three different reasons under 6460D to admit the evidence. Counsel addressed each of those today, and I will do the same. Starting with D1, the present sense impression. And counsel is correct that this court's case law says that there is a strict timing requirement, more so on that subsection than on the others. As I argued in the brief, I think that while it's a strict timing requirement, I don't know that the case law necessarily goes so far as to say that it has to be at the exact second that something is happening, that you're literally narrating something at the precise moment so that you're saying, he's now doing this, he's now saying this. In this situation, the statement was about what somebody else said. So I don't know that it would even be physically possible for somebody to be parroting somebody's comments at the exact moment that they're making them. There's always going to be some sort of a lag between the time that you hear the person make the statement.
Well, when the statement, the witness's testimony is not the hearsay in question. The hearsay in question is the statement of the declarant.
Right. But part of that statement was also not only that she came up with a gun, but also that she was.
But just to be clear, the gap in time that we're talking about is the gap between the event being described
Right.
and the declarant's statement.
Correct.
Not the gap between the declarant's statement and the witnesses.
No, exactly. But my point is there, when you're recounting, when the declarant is recounting not only something that she's seen, but I think her statement also touched on maybe what the defendant was saying, that she not only said, she came to my car with a gun, but then she said she was also tripping about this other person based on, I think, what she was saying and the statement that she made about this boy that was supposedly the source of the argument. Or
just to be clear, the best we can determine from the record is that this hearsay statement was made sometime after the initial approach to the car and before the fight.
Yes, it was definitely before the fight because it was while Cavett was still in her vehicle.
And do you have any sense of how much time elapsed between those two events?
Other than there's not direct evidence. I think you can certainly infer from the fact that Cavett had not yet got out of her car. And it's certainly, I think when you look at the record in its totality, it appears that maybe the argument between Cavett and the defendant was still ongoing at the car or near the car. So there's no precise timeline, but it was certainly not a matter of several minutes. I don't think there's any indication that it was a significant passage of time. I think Cavett is still in the vehicle.
These are effectively contemporaneous events. I mean, it's
Yeah.
in a matter of minutes.
Right, exactly, yes. And so basically what you have is her saying, she came to my car, she's waving this gun around, she's tripping about this boy. It was very much while this verbal argument was still ongoing and well before the physical altercation began.
Just real quickly, and I don't want to, I know you're going through the progression of the exceptions, but in terms of the giving of the initial aggressor instruction, was there any other evidence that supported giving that instruction other than these series of statements that are subject to them?
Yes, and I appreciate that question because I think it is very important. There absolutely was. Multiple state witnesses testified that it was the defendant who did start the ultimate physical altercation that led to the shooting. There were these two physical fights And then while counsel says that, well, the victim or the defendant was just going back to get her belongings, the state presented numerous witnesses who said, no, she came and she charged at the other victims. So there absolutely was. And of course the defense is.
Would those other, would that other evidence then support the, alone to support the initial aggressor instruction, or did it also require the hearsay statement?
I think that alone would have been enough. I think even without this statement, when you have testimony and evidence that the defendant was the one who started the final altercation that led to the shooting, that certainly would be enough alone. So I think that to the extent this court finds that none of the hearsay exceptions apply, that would absolutely lead to a conclusion that it was harmless.
Thank you. You can get back, go ahead.
No, I appreciate that question because that's a very important point. D2, excited utterance. I think that would be probably the most clear exception that would apply here, because the case law says that there's not nearly as rigorous a timing requirement for that than there is for the present sense expression. And the case law there are cases where the excited utterance has applied when the statement was made hours after the event. Here, again, we're talking about minutes, maybe not even minutes, maybe just moments. As far as counsel's argument that there was no evidence that the declarant Cavett was under the stress of nervous excitement, I think to answer some of the questions that this court posed, I think absolutely you can look at the totality of the circumstances here in determining whether this was something that caused nervous excitement. You don't have to have a situation where the declarant not only recounts the statement, but then says, oh, and by the way, I'm currently freaking out or panicked because of what I just witnessed. You have a situation where the statement is that this person just came to my car window with a gun and was tripping out. And AC, the trial witness, said that the declarant yelled this. So it wasn't like she was calmly recounting it. She was yelling the statement moments after it occurred. And it's not as if, I guess you could conjure up a scenario where somebody wouldn't be panicked by somebody coming to their car with a gun. Maybe if my friend comes to my car window to show off to me, hey, look at this cool new gun that I just got. Maybe that doesn't cause stress or nervous excitement. But when somebody comes to your car window, stands outside the window, brandishing a firearm, and is tripping about the source of this argument, I struggle to see any scenario where any declarant in that situation would not be under the stress of nervous excitement.
Do you think that the proponent of that testimony has to lay some sort of foundation for the exception to apply that's independent of the statement itself? You know, can you have a sort of self-authenticating declaration under this exception? Or don't you have to lay the foundation for that nervous excitement in order before you can actually get the statement in?
And I think we did that here through the testimony about the circumstances, both leading up to the statement and then what followed the statement. Basically, the witnesses said, look, we pulled into this parking lot. We saw that there was already this verbal altercation going on. We recognized that Cavett was one of the people involved. I think they also knew who this defendant was. So they come up, they already witnessed this hostile, heated environment where people are gathered around. There's this argument going on. And then one of the participants is saying, look, this is what happened. This is what I saw. This is what she said. This is what she was displaying, a gun. So I think that to the extent the statement itself, I think that there are circumstances certainly where you could say that the statement is self-authenticating. There are certain situations in life where the very incident or the very thing that the person is speaking about would be something that any person would feel stress, and that would be enough, I think. But to the extent that more is required, I do think that the context of the statement here would suffice to meet that requirement. D3, the unavailable witness. The court did make a finding on this. I know in the brief the defense argued otherwise, but the court very clearly said at the time that this was being discussed that if the state is not able to locate this witness, if she is unavailable, that the statement would meet that exception. And further, the state did present testimony on this. Lieutenant Miller testified that 2 specialized law enforcement teams went and looked for Cabot. So there was testimony, because I think one of the things that the defense argued in its initial brief was that the statements of a prosecutor just generally saying, well, we tried to look for her, wouldn't be enough. But we don't have to decide that question, because that's not what happened in this case. We did have Lieutenant Miller get on the stand and say, yes, I tasked 2 specially trained teams that are designed to go out and look for people to try and find her. And they were obviously not able to do so. And so I think that the prerequisite for finding her unavailable was certainly met in this situation, and that therefore the D3 exception would also apply. And I'd also point out that at the time that Cabot made this statement, there was no incentive to falsify. She was not making the statement to law enforcement. She wasn't making the statement at the preliminary hearing. She was making the statement to a friend at the scene moments after it happened. So I think it would be a stretch of any logic to suggest that she's saying this because she's trying to set the groundwork for any potential future trial or litigation in the case, especially because at the time she made the statement, no crime had happened yet. The defendant hadn't fired the weapon. The physical fights hadn't happened. It's just a verbal dispute at this time. And so certainly there's no incentive to falsify that statement when you're talking to a friend moments after the event that she perceived happened. So our position is that there are, like the district court found, that there are multiple 6460D exceptions that apply. Of course, only one would be necessary for the evidence to be admissible. So even if this court finds that 1 or 2 of the exceptions shouldn't have applied, that doesn't change the fact that the statement was properly admitted. And then to Chief Justice Rosen's point, even without the statement, there was independent evidence of the defendant being the aggressor immediately prior to the actual shooting itself. So for all of those reasons, we feel that this statement was properly admitted. If this court finds otherwise, we would find that any error was absolutely harmless. Again, I would submit the remaining issues on the brief unless this court has questions. Our position is that there were no errors in this case, and certainly no errors that would lead to any reversibility.
Colleagues, any further questions? Thank you, Mr.
Thank you, Your Honor.
Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor. Couple points. With the present sense impression exception, the state wants to say, well, there's essentially some wiggle room. And I don't think you can get there from the wording of the statute. The statute says, while the declarant was perceiving the event or condition with the statement narrates, describes, or explains. It has to be play by play. That's how it falls within the exception. And here, what we have is not play by play. And the testimony was, she made this statement, and the question was, and this is from volume 12, page 26, was the defendant near Amunique as she was saying this? Answer, no, she's all the way on the side of her car. So it's not, she's here waving a gun, tripping. It's, this is what she did a moment ago. And even if it's a moment ago, that is too long for present sense exception. The other thing with regard to evidence that my client was the initial aggressor, I don't think you can break up the fight and say, well, you know, 3/4 way in, she took a swing, so she's now the aggressor. This was an ongoing fight, and even looking at it in the best light for the state, that my client later came up and got engaged in a fight, that was all part of one ongoing fight. The critical question, I think, is who started this? Who started the melee? And these statements point the finger directly at my client. And those statements should not have come in. And they came in through Cavett, who had every reason to, hey, it's all on her. In the preliminary hearing, she said she was so drunk she didn't remember anything. There's every reason to doubt her credibility. But that could not be challenged because these statements came in through a third party as hearsay. That undercut my client's claim of self-defense, and we don't believe she got a fair trial as a result.
Can I ask, I'm going to go back to the question I had earlier about the instructions, but really what I'm trying to figure out is how the various levels of self-defense might apply to the felony murder conviction. That's kind of where I'm starting from.
Sure.
And I asked you earlier about whether perfect self-defense would negate the underlying felony. Let's just say that you're correct, that perfect self-defense can negate the criminal discharge. Is the same thing true of the imperfect self-defense, which those instructions were requested? That's part of your appeal.
Yes.
Can an imperfect self-defense also negate the underlying forcible felony?
We would argue yes.
And how?
Because when you get self-defense, our argument is that includes the lower levels of self-defense, the imperfect self-defense. It's essentially the homicide tree,
Right.
where you go down the tree.
If your client had been successful, let's say that your client had gotten the instruction and been successful and been convicted effectively of either voluntary or involuntary manslaughter, aren't those convictions also sufficient to support a felony murder conviction?
I don't think they would be, because I would think you would have a merger problem.
Well, how so? I mean,
I don't
so
think
I'm
you can
looking
be.
at the forcible felony statute, and it includes voluntary manslaughter, and it also includes any other felony involving physical force or violence. Wouldn't that capture both the voluntary and involuntary manslaughter convictions?
I don't think so, because, and I don't have the statute in front of me, but I believe, maybe I'm wrong, that those are under where these are sufficiently separate. Aggravated battery could support felony murder if the aggravated battery is sufficiently separate from the killing. And I think if you're going to
But it's
say,
still a criminal, I mean, it's a criminal discharge. You're saying that the conviction
Right.
would change from, or the underlying felony would change from criminal discharge to,
she would be convicted of, she may or may not be convicted of criminal discharge as a separate offense, but she would be convicted of the voluntary or involuntary charges, imperfect self-defense versions, instead of the felony murder. I don't think you can then turn and say,
well, we're
that's
looking
a
at the
felony.
underlying felony, and not to
The-
belabor the point, but I'm just trying to,
The underlying felony would stay the same. This underlying felony would be criminal discharge. But you're saying, okay, the underlying felony for felony murder is criminal discharge. As a lesser included of that felony murder charge, you can consider both voluntary and involuntary, because those are included defenses with her claim of self-defense. And it would be, I'm not going to draw a map because that probably would be difficult, but self-defense includes those defenses. And that's why the jury should have been able to consider them as alternative charges. Not alternative isn't the right word.
do you think that voluntary manslaughter is legally a lesser included of criminal discharge out of vehicle?
It's not.
I mean,
It's not a lesser included, I don't believe, of criminal discharge. It's a lesser included defense. And I'm not looking at voluntary and involuntary as lesser included offenses, but lesser included defenses. And you get it because there is sufficient evidence for the claim of self-defense, and that brings along with it those lesser defenses. as I said, we believe that that error, among others, denied my client a fair trial, and we would ask this court reverse this matter for a new one.
Thank you, Mr. Meharry.